Assalamu alaikum and peace be upon you all. You're welcome to this course, Sharia Intelligence. I am your host, Muhammad Nurudeen Lemu, and with me to discuss today's topic are two of our top facilitators, Brother Nasir Bello and Sister Salatu Sule. You're both welcome to the program.
Thank you.
Thank you.
Today's topic is going to be something called Istishab. Istishab is one of the very important secondary sources accepted by all the major schools of Islamic jurisprudence. Istishab is sometimes translated as legal presumption or the acceptance of the status quo. Inshallah, we will hear more about this from our resource persons, and I'd like to start with Brother Nasir and then Sister Salatu. What is meant by istishab? What do we mean by legal presumption, and why is it such an important source in lawmaking, and what evidence is there for justifying it as a source of law? So, Malam Nasir.
Okay. As rightly mentioned, istishab is actually one of the very important tools of ijtihad. It means assumption of continuity or presumption of continuity in matters of purity, in matters of prioritization, in matters of importance and significance, and of course in matters of stating the truth. This forms the basis for establishing ruling in Islam, particularly, or the general acceptable position or the default position is that everything is you build it on the default position, that is maintaining the status quo. So it's like the standing order that actually was established by Allah subhanahu wa ta'ala. Just like in the banking sector, you would find somebody given a standing order in his account that certain amount of money should be deducted. So the default position when it comes to Sharia ruling is that is what we call istishab. And what this is telling us, or what the tool of istishab in ijtihad is telling us, is you base ruling of Sharia on presumption of continuity, that it is now the responsibility of he who says otherwise to bring evidence that is certain. But what has been established is that presumption of continuity, that which has been established should continue. So if the default position that was established is permissibility, that means permissibility should assume to be continued until and unless something that is also certain is able to be is presented that will take you from that position of permissibility to something that is different. And therefore, when you have two people talking about innocence and guilt, the person who accused of guilt is the person that is responsible for providing the onus, or the responsibility of providing evidence lies on the person or on the shoulder of the person who talks about guilt, because the default position is innocence. And so also on the issue of purity, and that is why if you look at what Imam Sa'adi was saying about purity, about water, he said وَالْأَصْلُ فِي الْمِيَاهِ الطَّهَارَةُ وَالْأَرْضُ وَالثِّيَابُ وَالْحِجَارَةُ. The Prophet ﷺ said وَجُعِلَتْ لِيَ الْأَرْضِ أَرْضُ كُلُّهَا مَسْجِدًا وَطَهُورًا, that the whole world, the whole land, all over the world has been made pure. So the default position, the assumption is everything around is pure. And if you look at so many other hadiths of the Prophet ﷺ, where he talked about al-ma'u tahurun illa in taghayyarat rihuhu aw lawnuhu أو طعمه بنجاسة تحدث فيه, that every water you see is pure except if that has changed. So the assumption is purity. The assumption of matters of rulings is permissibility. The assumption of matter on almost everything, the assumption when it comes to people is that they are innocent until proven guilty. So basically that is what scholars say about the concept of istishab and how they look at it. So the general position is you work with asl, you work with the default position of assumption of continuity in terms of, and that is why they use it as the basis for given reason. And generally when it comes to issues of Sharia, we stick to the istishab, and that is why you find all the madhahib, all the schools of juridical thought agreeing on this particular tool of istishab.
Thank you very much. So basically, istishab or legal presumption is a set of legal assumptions that set the foundational ruling for everything. So you've given an example of one foundation, which is that there's a legal presumption that everything is permissible except what is prohibited. There's a legal presumption that everybody is innocent until proven guilty. There's a legal presumption that everything is pure except what is proven to be impure. Sister Salah, what could you add to this, especially in the area of the justification?
Right, the justification for Istishab as a tool of legislation comes from both the Quran and the Sunnah, and also the practice of some of the highly regarded companions of the Prophet. For instance, there are those verses of the Quran where Allah mentions in one such verse telling the Prophet ﷺ, and by extension anybody else, to ask or to say, who has forbidden for you those beautiful things which Allah has provided, and those things that are pure which He has given to you. So there's a presumption that everything that Allah provides, that we can ascertain that this is good, it is beautiful, it's an adornment, it enhances, it improves, that those things are all permissible. And the challenge therefore is, who is the person who would then say what is halal is haram? Another such verse of the Quran is the one where Allah mentions that He has subjected, made accessible to us everything that is on earth. Again, tying in with what Brother Nasir was mentioning, this question of everything around us is permissible. There's a presumption of that, and that's the springboard from which matters will be discussed. Such that if a person steps forward to say this is not permissible, then we go back to that verse of the Quran. Who says it's not permissible? Another way of expressing that would be, where is your proof that it is not permissible? We have cases in the Sunnah, from the Sunnah, that shows us this concept in action being applied to specific cases. For example, what we were taught, what Muslims are taught, that if you are praying and you can't remember how many rak'ah you've prayed, or you are confused, you forget, you get distracted, and you're thinking, did I pray 3 rak'ah or did I pray 2? What we are taught is go with the lesser number, because you are sure of the lesser number. You therefore go from that which is established, which is 2, you are sure of this, it is set, and you assume that's the status quo, and act based on that, and you act on that basis. When we look at where's the evidence for Istishab from the companions themselves, we'll take the case of Umar. As we know, when he was the caliph, he had this habit of going around the town, especially at night. One time he was walking around and he was with somebody. Then a man from a house threw water out, and the water splashed on them. So the person with Umar radiallahu anhu asked the man, that is that pure or impure? Apparently wanting to know, do I need to go wash my clothes? Do I need to do anything? And Umar immediately interjected and told the man who poured the water out not to answer that question. We are going to assume that it's pure and keep right on going. When we look at this particular tool, we also appreciate the fact that it creates ease and doesn't put an unfair burden on somebody to prove that something is permissible when there is enough evidence that generally the presumption from the beginning is everything is permissible.
This is interesting. The case of Umar and the examples you've brought, that and I think you touched on this issue, that Istishab, this tool, sets the default setting for the legal position of Sharia, which is that everything is halal by default. Yeah. It is the person saying it's haram that needs to bring evidence. The same thing with innocence as the default. And there are some words you used where you said Istishab sets the priority. In other words, which is a priority, innocence or guilt? It also establishes which is more important, that innocence is more important than guilt. It also sets which we are more certain about. We're more certain from the Quran and the Sunnah that people are innocent by default than to say they are guilty. I'd like to look into each of these one by one. Could you give us some examples of these default legal presumptions And in other words, could we have more? What are they, and what are examples of each of these default assumptions?
Okay. One is the presumption of the status quo remaining, or you might say generally presumption of continuity in a sense, continuity of the status quo. That presumption has several examples, rulings that were made based on that example, or rulings that highlight this presumption. One such ruling is the ruling that if people are established to be married, that's a couple established to be married, that marriage remains, unless there's strong evidence to the contrary, such that a person making some statement that might mean that the person has divorced the wife. The presumption would remain that they are still married unless there's clear evidence that that statement or that action constitutes divorce. Another such ruling that comes under this presumption of the status quo is if somebody goes missing, it's presumed the person is alive. For instance, someone is kidnapped, and people say, well, the kidnappers usually call to say they want such amounts as ransom, or the last time they called, they threatened to kill the person. We've not heard anything from them for the last 3, 5, 10 days. You still can't assume the person is dead. So if the person is married, the marriage remains. If the person has property, you don't start sharing the wealth unless there's evidence to prove or to safely assume that by now this person is definitely dead. Another such example comes from Ibadah itself, where if a person breaks wind or thinks they might have broken wind because the person says, well, I felt something, because we have that specific case of someone saying, I felt something and telling the Prophet sallallahu alaihi wasallam, but the person wasn't sure, did he break wind or didn't he? So the Prophet sallallahu alaihi wasallam then said that unless you hear a sound to go with that sensation, which you are not sure of, or you smell something, assume that your ablution is still intact. So those are examples that give strength to this presumption of the status quo remaining. Another presumption is the presumption of purity, that everything is pure. And Brother Nasir cited some evidence to prove that. When we say, okay, let's look at some rulings in action on this, we look at the presumption that everything you're going to eat is pure. If someone serves you food, you assume it's pure, unless you have strong evidence, you have evidence strong enough to the contrary. There's the assumption that if I'm eating something and there are some food additives, I'm not going to start off with the assumption or presumption that the additives must have haram substances in them. I will assume it's all halal, except there's something to the contrary. We also find that there are scholars who extend this even when they are talking about the ruling regarding alcohol. Is it physically impure? Meaning just alcohol by itself, is that impure or is it pure? There are scholars who say it is pure, physically pure, because when Allah mentions in the Quran that khamar and maisa are najas or rijisun from the works of shaitan, what Allah was referring to was not physical impurity but the moral impurity, because that particular verse is talking about khamar, as well as khamar is intoxicants or liquor, and maisa, which is gambling. And for gambling, there would be money involved. So it's not money that is impure, it's the moral impurity of these actions. So for such scholars, they then say, so the assumption remains that even alcohol, when it occurs in sanitizers or perfume and other such things, is physically pure. Another presumption is the presumption of permissibility. The presumption of permissibility or free choice is that everything is permissible. We can make certain decisions, we can take actions, and unless someone proves to the contrary that this is not permissible, then we assume we have the freedom to make these choices. So in a society, people are free to make policies, they are free to engage in communal life, to engage in acts of commerce, they are free to establish relationships, set up organizations, they are free to travel, they are free to choose ways of caring for the environment, they are free to make choices about healthcare, unless it's proven clearly that a certain action, a certain decision is not permissible, then the presumption remains that whatever you wish to do, go ahead and do it.
This is interesting. So this presumption of permissibility assumes the default that you can travel anywhere you want,
Yes.
you can live anywhere you want,
Yes.
you can
By any
eat
means
what
of
you want.
any means of transport.
Yeah, you can have any forms of entertainment, any sports, everything is halal except what is haram.
Yes. And this this last the last one I mentioned, this permissibility, the presumption of permissibility is particularly applicable to mu'amalat. I think I just need to emphasize that, particularly applicable to mu'amalat, that is our mundane transactions, interpersonal transactions. When it comes to acts of ibadah, then there's a shift in that presumption.
Okay, and I think that's where differences of opinions would then begin.
Yes.
Brother Nasir, I know we've got a lot of these legal presumptions. Could you add more? We'll come back to...
Well, I think another important presumption is the presumption of innocence until proven guilty. And that is why that every human being is born free, is born with his dignity and reputation, and that need to be protected. If you accuse somebody of something, the assumption, the presumption is he is innocent until you are able to prove beyond reasonable shadow of doubt that he is guilty. Because what was default, the default position is he is an innocent person. And doubt in whatever form or shape cannot displace people or anybody from that understanding until you are able to build another certainty that will displace that position of understanding that is guilty. And that is why if you look at the Quran, there is stipulation of punishment for qazab, for accusation, for slander against somebody, in order to protect that innocence, exactly, that fitrah of human, that freedom and what have you. And that is why whatever somebody is accused of, until it has been established by a competent court, by a court of competent jurisdiction, that cannot be, he will not actually be accused of somebody that has committed such an act. Or a child that is born out of wedlock, for example, you cannot accuse him of, you cannot touch his dignity or his reputation, because it is not his fault and he is not liable for any mistake committed by any person. So as a human being with that reputation that is embedded as a birthright, he always has it. So that is basically what this presumption is trying to explain and is establishing. The second presumption is presumption of fulfillment, obligation in the fulfillment of contract, that whatever you commit to, you are obligated to ensure that you are able to discharge your responsibility. That is an obligation, and that is applicable to the domain of marriage, a relationship. And that is why if you look at some of the scholars, when they talk about, they see marriage more like business transaction, and usually contracts are in business, in marriages and what have you. And there are things that ab initio they are not part of the stipulation of responsibilities in marriage, but at the stage of contracting marriage, if these things are negotiated and agreed upon, then you become liable. Why? Because of this fulfillment of obligation in contract. And this is also applicable to international treaties across between countries, in treating prisoners of war and all that. Anything contract that you've committed to, so long as it does not trample into the rights of God, so long as it does not trample into the right of God, you then have to stand by it. You are obligated to fulfill it. And the last one in this segment is the presumption, of course, of the presumption of literal meaning when it comes to interpretation of language, that the first meaning you give to any statement or whatever you read is the literal meaning. You don't imply, you don't go metaphorical or allegorical in interpretation. If somebody says, this is my sister, the assumption is she is his biological sister. If he says, this is my daughter, the assumption is she is his daughter. If they say he beats his wife, you cannot just assume maybe in a game. No, it means he beats his wife. So that zahir, that literal meaning is the first interpretation that is given to. That is the presumption, except if you have a reason to go beyond the understanding of zahir, or sometimes there's what we call more wisdom that can be extracted And usually when it comes to even prioritization and interpretation, except if there are compelling reasons to think otherwise, priorities are given to the literal interpretation of language. Now,
excellent. Salatu, could you add more to this?
Yeah, a few more presumptions. One is related to something he mentioned. That's the presumption that once it's established that a person has a duty, that duty remains, and it's presumed it stays until the person can prove, or there is proof that the duty has been discharged. For instance, in Islamic law, the man is the head of the family and is responsible for the financial and the material needs of his wife and their children. That presumption remains unless the man proves that he has discharged his duty. Another presumption, which is similar to this, is the presumption of freedom from responsibility, where we assume that a person is free of responsibility unless there's evidence to the contrary. And this presumption is applied in cases of the duties of a wife. You know, in some cultures, it's taken that the woman's duty is to cook, to do household chores. If we want to go strictly by Islamic law, it's presumed that she's free of such responsibility. Of course, you might have contractual agreements that surround these things. You might have mutual agreement between the couple, but we've been using this term, the default position. Default position is freedom from responsibility upon her in such a case. Another one I would like to add is the presumption of the sacredness of life. When it comes to life, the life of animals, insects, human beings, of course we start with human beings as a priority, but we find evidence in the text that even when it comes to the life of animals, it's sacred. And life is not to be taken lightly or for sport, or even in cases where there might be justifiable cause to say this person's life is no longer as sacred as that, such as where a person commits a crime, where the punishment, the stated punishment, is death. I, as an ordinary individual, can't say, well, he did such, and I know the law says whoever does such is liable to be killed, then I will go ahead and execute it. Even in such cases, the sacredness, the weight given to life requires that before such a decision is taken, before such execution takes place, there are established steps, legal steps and procedures that must be followed, clear proofs, clear establishments, and so on. So this presumption of the sacredness of life is one of the, you would say, primary objective of Islam, of Sharia. So that presumption is an important one to note as well. And when we look in the text, we see cases, statements such as even if it's a bird, anything with life, you don't use it for target practice. That was a statement made by the Prophet ﷺ. He disapproved of that strongly. You do not burn down an anthill. And you say why? Well, they were in the way, the anthill was in the way, the ants were bothering me. We see hadith where the Prophet ﷺ disapproved of that very strongly and actually made a statement that that's a community, just like a community of human beings. So the sacredness of life is a core presumption under this rule, Istishab.
This is interesting, that every living thing, you can't just cut down trees, you can't just kill animals for sport, for no reason. Yeah. There must be a reason. Either you actually need the firewood, you actually need, but not just wasting of life. Yeah. Brother Nasir, what are the last ones you will add to the list of legal presumptions?
Well, I think another important presumption is the presumption of prohibition of accruing, afflicting harm to anybody, irrespective of his status, his circumstance. And that goes beyond even the human beings, that affect the environment, that affect the animals, that harm, abuse, oppression in whatever form or shape is prohibited, and against whoever is prohibited. It could be in the form of insult, it could be in the form of action. That is what this is exactly saying, that you don't insult, for example, a non-Muslim with names that ordinarily he doesn't like. So if he doesn't like it, it harms him. Why would you do it as a Muslim when you have obligation that you are prohibited from inflicting harm to anybody, inflicting harm to animals? Look at what Rasulullah said regarding slaughtering animal. He said, if you have to slaughter an animal, then you have to sharpen your knife so that at least it is not going to afflict harm to the animal. That will hasten the process, that will make it very fast, and that is what Rasulullah says about that. No cruelty to animals, and about the environment, because somehow this environment, if you preserve it and you protect it, somehow you are bringing something that is beneficial to humanity. And if you bastardize the environment, if you do some things that affect the health and the well-being of the environment, indirectly you are bringing harm to humanity and all other creatures around. Another important presumption is, of course, the presumption that justice is equality in terms of moral responsibility, in terms of reward, in terms of punishment. That identities, that equality and justice, and not attaching any prejudice in the way you treat people is prohibited. I mean, treating people on the basis of their identity or being prejudiced against people on the basis of their identity is prohibited. And reward, punishment, compensation should be given to people equally. When you have to treat people, when there is reason for equality, you have to justify it. When there is reason for equity, meaning based on people's ability and performance and what they were able to present, then that has to be justified. Otherwise, justice is the norm, justice is the default position, that everybody deserves to be treated justly and with all fairness. And the last one is presumption of that sexual relationship is prohibited. That sexual relationship in whatever form, be it incest, be it homosexuality, extramarital affairs, whatever is prohibited except through marriage. So this is the last presumption.
Interesting. Which probably is a flip of everything is permissible except what is prohibited. Absolutely. Also. And so I think this makes it really clear that the default, as you've mentioned, for justice is equality, that you treat your wives equally, you treat your children equally, you treat citizens equally, that there has to be a very good reason why you should not handle them equally, and that equity and what each deserves should be the rule, but that the rule is whatever is haram to all alike. So there's no, in this type of sin men get this punishment, in the same sin women get a different punishment. If a woman does this good deed, she gets more reward than if a man does exactly the same deed. So we see this issue of the default of justice being equality, and of course the ones you brought on, prohibition of cruelty, that cruelty by default, any form of wickedness is haram, whether it's in form of cockfighting, certain forms of factory farming in agriculture, where there's a lot of harm being done to birds and animals in the name of food production, to really be very sensitive to these. There's a lot of these legal presumptions. I'm interested in our looking at the differing opinions among scholars and jurists regarding istishab. Malam Nasir, what more could you tell us?
Well, I think regarding this very important tool of istishab as a tool of ijtihad, you hardly can find any scholar or any mazhab, any school of juridical thought differing or disagreeing or not accepting this very important tool. What seems to be obvious is the fact that the diversity or the difference of the opinion is in the exception to that ijtihad. I mean, that is the tool of istishab. The exception to this default position of permissibility, maintaining the status quo. What makes an exception? Whether it's strong enough to make the exception, that is where you find scholars differing. And another thing that is important is all these presumptions that were discussed are actually somehow trying to help in the attainment of the maqasid, and also trying to help in protecting the spirit of what we call the Islamic legal maxims.
This is very true, I think, especially when we look at one of the maxims which we will be coming to later on. Among the universal maxims, al-yaqeen la yazulu bi shak, that certainty is not overruled by doubt. Istishab seems to be that maxim of qawaid in usulul fiqh, as we will see probably the other way around, that maxim is actually istishab in qawaid al-fiqhiyah, so this interrelationship. Sister Salah, what would you add to this?
Yeah, just riding on that last statement, when we look at some of the presumptions, we can trace what they are protecting, which of the values of Islam, the high intents of Sharia, are they protecting. For instance, this presumption of innocence protects that higher intent of adl, justice, that it's only fair to assume that everybody is innocent if we are all born innocent until you can prove that the person is guilty of one thing or the other. Or the presumption of freedom from responsibility or permissibility, which helps protect that divine part of our fitra, which is the freedom of choice, which is one of the things that we know marks us out as human beings. We have high intellect plus freedom of choice, where we see even in the Quran Allah saying La ikraha fid din. So even when it comes to the highest purpose of human existence, worshipping Allah, He, the Creator, will not force anybody to do so. So when we go by way of presumption of permissibility and presumption of freedom from responsibility, in a sense we see that freedom of choice being preserved. There are so many other higher values that these presumptions help to preserve. We've already mentioned justice, we've mentioned innocence, we can also look at protection of the family lineage itself, when we look at the presumption that all forms of sexual intercourse are considered haram except they happen within marriage, which also has an impact in how people are raised, the kind of environment in which they are raised. Ultimately, when we look at all the presumptions, what they keep trying to add to is the maximization of certainty and the preservation of those things that Islam accepts as proper, as okay. We think also about customs, that if a custom exists among a people, it presumes the custom is okay, that everything about the custom is good, it's fine, unless you can prove to the contrary that an aspect of that custom or culture is not acceptable, which also enhances communal life and allows wisdom, human wisdom, experiential wisdom to be passed from generation to generation through the preservation of good custom.
Thank you very much. And I think, as you've mentioned, some of the differences of opinions among scholars on this topic from some of the schools rests in first saying that before there's a legal presumption, there has to be evidence for that legal presumption. And you've shared some of these, and each of these we find in the life of the Prophet ﷺ and in the companions, how they assumed innocence until proven guilty, permissibility until proven otherwise, freedom until proven otherwise, and all of the examples you've given. And where again you said, while that is the default, that for example everything is permissible except what is prohibited, the difference would come in whether a particular school or jurist regards the evidence as strong enough to establish a prohibition. In other words, to become the exception of the status quo. That the status quo is the general rule on everything, and evidence is required to make an exception there. I'd like to thank you both for your contributions and enlightening discussions. Jazakumullahu khairan. Until next time, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuhu.
Wa alaikum assalam wa rahmatullahi wa barakatuh.